Kerri Kupec Urbahn is a Fox News legal editor. She does a great job of covering everything legal, including the Donald Trump trials in New York for Fox News. I was with her on Fox and Friends the other weekend. I was super impressed with all of her legal analysis. Wanted to get her on the show, and I can see you, Kerri. I'm not sure I'm going to be able to hear you.
I can hear you.
Oh, it's a miracle of some technology. That we got you here today on the Cain Show. Thanks to the audience for being patient. Thank you for Kerri for being patient. So I was joking. I'm consumed as I often am with sports, and I'm consumed with hockey right now. So, there's only 3 periods in hockey. I was thinking, well, we're not halfway into the Donald Trump trial in New York, but we're kind of a third, maybe. So I think what what many of us need to do is sort of just take a moment now, almost like the studio show between the first period and the second period, and say, where are we? Like, how is this going? The prosecution's still putting on witnesses. There's still many of the heavy hitters left to go, Stormy Daniels and Michael Cohen. But as you stand today, how do you think the prosecution has done in its case against Donald Trump?
Well, they haven't proved that he's done anything illegal yet, which is the whole point being in court. The former president is on the first to stand as in a criminal trial. And you'd think that if a state or the federal government was going to bring a case against the leader of the free world and possibly the next one again, that they'd have an airtight, rock solid case. And they have the opposite of that. We've heard a lot about catch and kill schemes, which is when a media company buys the rights to a story, it doesn't publish it, not illegal. We've heard a lot about compensation for a non-disclosure agreement, also perfectly legal, not a problem. People may think it's sleazy, but it happens all the time, and there's nothing illegal about it. And we've heard a lot about his desire to suppress bad stories about himself, which, again, not illegal, and we're in the court. So it's unclear where they're going, Will, other than I think they're continuing to look for a crime as they go, which, of course, is the opposite of how the justice system should be operating in America. So
the crux of having to prove a crime here will be they have to prove a felony because the misdemeanors have run their statute of limitations, right? And in order to prove that it's a felony, they're going to have to prove, it would seem, Kerri, that his intent, as you said, in suppressing stories, not a crime, but his intent was to subvert an election, right? And how do they do that? Like, how do they prove, even if they prove that, he made payments to Stormy Daniels or to Michael Cohen to facilitate them to Stormy Daniels, how do they prove that that was done in furtherance of an election?
Well, right. And that's the problem, I think, on its face with the New York state law that's at issue here. And the law says something like it is, so for somebody to promote a candidate by unlawful means is a crime. But the question is, promote a candidate, well, what does that look like exactly? And as far as unlawful means, it's very vague on its face. So effectively, a prosecutor could write into the law what they want it to be as they go along. Now, I will say this, while the misdemeanors have run on the 34 counts of falsifying the business records, they still have to establish that, though. I mean, they can't have one without the other. And so the reason that matters, and the reason I'm drawing our attention back to that, is because these payments to Stormy Daniels were classified in Donald Trump's personal ledger book by his accountant as a legal expense or a retainer. And the reality is that compensation given for someone signing a non-disclosure agreement could be characterized as a legal expense. In fact, I thought it was very interesting that last week, the lawyer for Karen McDougal and Stormy McDaniels was on the stand. His name is Keith Davidson. And he refused to call the payments to his client, then client Stormy Daniels, as hush money payments. He said, well, no, it was consideration, which is a fancy legal term for something that you get in exchange for a contract. You abide by a promise. So he's calling it consideration. Donald Trump's bookkeeper called it, a legal expense. And I guess the state would like him to have said reimbursement to Michael Cohen for Stormy Daniels, but it's really all one and the same thing. So they have to establish that even before they get to this underlying, concealing of a crime, which is a felony, which again remains unclear exactly what that was.
All right. But Kerri, so you're an attorney, and I went to law school, which makes me just dangerous enough to be stupid on this. But so in the normal course of business, and I'm just curious on this, if you were going to make a non-disclosure agreement, would the client make that agreement directly with the subject and then therefore make the payment directly to the subject, or would they do that facilitated through their lawyers and then have the expense umbrellaed as legal expense, because that's what Donald Trump did the second, right? It was all funneled through the attorney as a legal expense. Would that be a normal course of business?
Yeah, it would be. And in fact, to your question, which is a great one, the lawyers have, or Keith Davidson, again, the lawyer from McDaniels and Karen McDougal, testified that he worked directly with Michael Cohen. And I thought this was a very interesting point of his testimony. He said, and again, I think this is important, he wasn't sure rather, that Cohen even had the authority to be making this payment to him, to Stormy Daniels, that it was just done between the two of them. Keith Davidson never had any interaction with Donald Trump himself. And again, that's important because Donald Trump is the one currently on trial, not Michael Cohen. And then whether Cohen even had the authority to do this or he was just taking care of stuff for Donald Trump as his, quote, fixer is unclear.
So, but when you say normal course of business, we would see other attorneys conducting another business this way.
Between each other, of course. Lawyers negotiating a contract between, of course, that would be the normal way of doing things. So,
and then making the payments directly themselves, I'm saying, and then billing the client under legal expense.
It really depends on how one classifies a retainer. Right? So it goes to the heart of the state's case. So if a retainer, if you pay someone a retainer, that can include a lot of expenses. And, it depends on how much the client wants those expenses itemized within the retainer. So if Michael Cohen was tasked with fixing problems and he decided that he was going to go all in, and that included in his mind to pay off Stormy Daniels because he thought that would hurt his boss, Donald Trump, he could have done that without consulting with Trump. It would be surprising, frankly, if he hadn't consulted with Donald Trump, because that's a lot of money. And that obviously is a point of contention between the state and prosecution right now. The prosecution and the defense. And that came up with Hope Hicks's testimony on Friday, where she said it was hard to believe that Michael Cohen would have done this out of the goodness of his heart, given that he wasn't a charitable character and Donald Trump was likely to have known. But even then, even if Donald Trump knew and worked it out with Cohen, who then paid Stormy Daniels, it's not illegal.
Right. And so I'm focused on the misdemeanors, like you said, because first you build the misdemeanor, then you build the felony. Right. They have to go hand in hand. In the misdemeanor charges, 34 counts of fraudulent business transactions, right? They should have been classified as whatever, NDAs instead. And in public, we're all saying hush money, but this is the prosecution. But this is the prosecution's argument, right? Right. They should have been classified as NDAs. You classified them as attorney's fees, retainer, so that you could hide that you made these NDAs. And it would seem to me, if the defense could say, this is done often, the way that these business records were transacted and recorded, the way they were recorded is often done. And if it's often done, then it's not a fraudulent business transaction.
Right. And the other thing they would have to prove, again, the standard is beyond a reasonable doubt. The prosecution has to prove that Trump had actual knowledge of how these payments were even classified. And again, that's putting aside the fact whether the legal expense classification is even legally problematic, but they still would have to prove that he knew. And that's also unclear, given the fact that my understanding of the case thus far is that the person who labeled them as legal expenses was somebody at Trump Tower. I think she may have been an accounts payable supervisor or someone who was lower in the chain, so to speak. And whether Donald Trump even knew what she wrote in the book is unclear. And maybe Michael Cohen's going to testify that she did. But again, then it comes down to Michael Cohen versus Donald Trump.
And so what we're talking about is whether or not they can prove beyond a reasonable doubt that these were fraudulent business transactions. Then there's the next step. Well, even if they were capable of proving these misdemeanors, he's guilty of these misdemeanors, in order for it to be a conviction at the end of this trial, they would also then have to prove the felony side of this, right? Which is that it was fraudulent business transactions to influence an election. Is that what the implication is?
Well, it's to conceal another crime. It's even broader than what you're saying. And it appears that the other crime is related to this New York state law that they have cited, which makes it a misdemeanor, by the way, not even a felony. But once you combine the misdemeanor plus the misdemeanor, you get the felony for purposes of what they're doing here. That it is to influence an election, to promote a candidate by, quote, unlawful means is a crime. So that's what they seem to be honing in on. But again, what are the unlawful means? Unclear. And number two, If it's a federal campaign violation, which would make sense given that he was running for federal office, the president of the United States, they don't have jurisdiction over that. They don't. It's a state court. And secondly, the Department of Justice declined to bring that kind of campaign violation against Donald Trump when they had the chance. So they don't have jurisdictions to bring it. The Department of Justice declined to bring it, who had the proper jurisdiction, which means we're only left with this vague New York state law, which is unlawful means, influencing election. What are those unlawful means? The state has not yet proved that case.
Well, wouldn't the unlawful means be the misdemeanor fraudulent business transactions? So that's what they're saying is the unlawful means of influencing election, right?
I mean, but in what sense? If it's classified as a legal expense, the NDA itself is not illegal. It's, the fact that, think about it, that what they're doing is they're looking they're looking through the books, the codes in New York, and looking for something they can find where they can match Trump's behavior with this very vague statute, when the thing itself, which is the contract and the NDA, is not inherently illegal, and it is a legal document, thus a legal expense.
And why I'm for those watching, maybe like, okay, you're getting caught up in the all the charges, but this is what it's all about, because then every witness that takes the stand, Kerri, has value in so much as, this is how it should work. It may just work that all the witnesses are there to try to influence how the jurors feel about Donald Trump, but that I can't analyze as well. Assuming that the jurors are listening to testimony and how their testimony proves the charges, I'm just trying to take what's happened so far and what is expected to happen as far as what Hope Hicks had to say, what David Pecker had to say, what Michael Cohen will have to say in terms of proving, A, that these were fraudulent business transactions, these NDAs were recorded fraudulently, and B, that they were unlawful in influencing an election. So I'm trying to anticipate, like, when's the big moment that if you and I are sitting here, not at the end of the first period, but we're sitting here at the end of 3 periods, did the testimony add up to the charges?
Yeah, I don't know that we're ever going to see it, although the state is determined to have that moment. I do think it's bad for them when every single witness thus far has had only negative things to say about Michael Cohen, who is their star witness. Michael Cohen, of course, who has lied in court, lied to the media, lied to Congress. If I'm the prosecution, I'm not feeling so great that the path that has been paved for Michael Cohen is all bad, whereas actually a number of these witnesses have had good things to say about Donald Trump. And, some of the bombshell, I've seen some of this reporting on a bombshell testimony, bad for Donald Trump. And I'm thinking, what bombshell testimony? Are we sitting in the same courtroom? If bombshell testimony is Hope Hicks testifying on Friday that the Access Hollywood story was bad for his campaign, everybody knew that. You don't have to, be a publicist or go to law school to know that that was going to be damaging to his campaign. And she's his press secretary. Of course it was. And she had to deal with it. Or the fact even that Donald Trump may have known what the payment to Cohen, that he knew what Cohen was doing. Again, even if he did, and I'm surprised, to be honest, that the defense isn't owning this more. I don't know why, as a matter of strategy, the defense just hasn't said, yeah, Trump knew. This is what he did, and there's no legal problem. It's perfectly fine.
And I think we've had this conversation. I know I've said this, like, if you did that, if you said, yeah, Trump knew and he did this, and by the way, he's done it a lot. Right. He's made NDAs about stories that are not favorable to him. It would almost inoculate him from the idea that he did it to unlawfully interfere in an election.
Right. And what, again, is unlawfully interfering? Conspiracy to influence an election is also called running for office but it is, right? And so it's like, at what point, who's drawing this line, this legal line, and what is it exactly? You can't just say, well, he did it unlawfully and then hope it sticks. Well, you have to prove what he did illegally. And I don't think that, they've done that yet.
And every politician, to your point, like, every politician's done this, right? Made stories go away, probably for consideration, right. And then not screamed from the mountaintop, here's what I did. I think, didn't Hillary Clinton have an on-the-nose situation like this where I think it was through Mark Elias?
Yes, but she was
where they've made stories go away.
Right. What she did was, and this is how she got away with it, was that she had her lawyers, handle the dirty work. Then the lawyers got immunity and were able to talk about what happened. But because they were the ones who did it, it wasn't, she wasn't charged. She wasn't part of that. And that's the same. And so, one thing that has just been surprising to me in this trial is how determined the state seems to be to equate dirty with illegal in the minds of jurors. When I was at the Department of Justice, people would get frustrated with Bill Barr. That's who I worked for not prosecuting certain fan favorites on the right, by the way. This was coming from the right. We took a lot of incoming on the right on this kind of stuff. And, I would constantly be defending our decisions in the court of public opinion. And I would be having conversations with people saying, just because something is dirty doesn't make it illegal. And I think that's what we're seeing again here in New York. But we're in a court of law. Elements need to be proved, and the standard is beyond a reasonable doubt.
And that's what I'm focused on, because maybe because I went to law school, maybe because I like the law.
Mm-hmm.
It's almost like math.
Right.
Not that I like math, but here are the set of elements.
Right.
Here is the proof. It should add up together to an equation for a juror that should add up. The equation should be, does it prove it beyond a reasonable doubt? So looking forward really quickly, you'll get the headliners soon, maybe this week, right? Stormy Daniels, Michael Cohen. In your mind, Kerri, what could they say that would be a bombshell in terms of proving the elements against Donald Trump?
Well, I think what Michael Cohen is going to say, because clearly this is what the state is building up towards, is that, he and Donald Trump had this elaborate conspiracy together where they were going to influence the election in this illegal way by paying this off and not reporting it as, again, this is where it gets, I think, very strange and murky, if this is what the state is trying to do, as like a campaign contribution to himself, which doesn't really make sense considering it's his personal attorney. He can pay out of it from his personal funds, no problem there. I think that's what he's going to do. But here's the thing that it's confusing as well. You can't conspire with yourself. So why hasn't anyone else been charged with conspiracy if that is part of the state's plan? Because in their opening arguments, they talked a lot about, they used the word conspiracy in this very scary way. And I thought, again, that's obscuring the issue to the jurors because no one else has been charged with that. And conspiracy in and of itself is not legally problematic unless you tie on some illegal conduct to that. And I'm still not clear what the illegal conduct here is.
All right. Will we see Stormy Daniels and Michael Cohen this week?
We don't know. We don't know until they walk in. We've not been provided with that information in advance, so it's possible, but we'll have to see.
Well, last question. Will all of this add up, Kerri? Again, in a way, it's not naivety, it's idealism. Like the law is logic. Right. That's what I like about it, not math. It's logic. Mm-hmm. And logic is often A plus B equals C. Will it be that way, Kerri, at the end, or is this whole thing designed to make Donald Trump look bad? I'm not even talking about outside the courtroom, inside the courtroom. Make him look bad to jurors that will decide this emotionally. I like him or I don't like him, guilty or innocent.
Mm-hmm. Look, I think that's always the name of the game in these kinds of trials. But I am very interested to know what the lawyers on that jury are thinking.
Those two lawyers.
Yes. Yeah. Because they know better than anyone. Got to have a crime, got to have evidence. There's a standard beyond a reasonable doubt. And even the fact that both David Pecker, who was the publisher of the National Enquirer, and Hope Hicks, his former comms director and press secretary, testified that Donald Trump was upset about the Stormy Daniels story having an impact on Melania and his family. And that was stressful to him, that their opinion mattered to him. That also undercuts the state's theme, which is he did this purely for the election. Well, what if both are true? What if he did it for the election and he was also upset about the impact it would have on his family? Doesn't that cast doubt on beyond a reasonable doubt? He only did this to influence the election, right? And so these are the kinds of things I think I would hope at least the jurors are considering as the state, I think, again, remains determined to conflate dirty with illegal in their minds.
Well, I know you've been down there. I know you've been in the courtroom. You probably got to get back. So first of all, thank you for doing this today. Thanks for being patient through the mess that was the start of this show
It's
today.
fine.
Your feedback is awesome on this whole story, Kerri. Thank you so much.
Thank you.